Testing 1, 2, 3. Testing 1, 2, 3. Oh, now it's too loud. Yes.
Speaking first, you know. I'm sorry. Who only speaks first?
Chairman, I'll chime in with that, Mr. Thing.
Oh, okay, I see it right. Sorry.
Yeah. All right, let me know if you can. This sounds good. Testing 1, 2, 3. Testing 1, 2, 3. Low, low. Little. Testing 1, 2, 3. Good? Okay. Okay.
All the speakers are pointed that way, so.
Yeah, okay.
The commission will come to order. The Federal Maritime Commission is meeting today for the oral argument in docket number 22-12, International Longshoremen's Association versus Gateway Terminals LLC, Charleston Stevedoring Company LLC, Ports America Florida Inc., Ceres Marine Terminals Inc., and SSA Atlantic LLC. Before we begin, the Secretary will provide an overview of the timing system for the councils. Mr. Secretary.
Good afternoon, Mr. Chairman, Commissioners, Councils. The clock system is set based on the time the respective parties have requested for opening argument, response, and rebuttal. Complainant has requested 20 minutes for opening argument. Respondents then have 30 minutes. Following that, complainant has 10 minutes for rebuttal. When you begin your statement, the green light will turn on. When you have 2 minutes left, the yellow light will come on. When you are out of time, the red light will come on.
Thank you, Mr. Secretary. Before getting underway, I just want to give a special thanks to John P. Sheridan and your team, and Matthew Thomas and your team. Oral arguments aren't the most common thing that we do, but we very, very much appreciate both of your work on this case and how important it is to have good counsel. So I want to thank you for that. We will start first, of course, arguing on behalf of the complainant is Mr. Sheridan. Mr. Sheridan, you have 30 minutes, but I understand that you've reserved 10 minutes of that 30 for rebuttal. So we'll set the timer at 20. Please proceed.
Good afternoon. I want to again thank the commission for giving me the opportunity to explain the ILA's position in this matter, and I appreciate that courtesy. And you've given me plenty of time to do that, so I'm going to try to set up the situation from the beginning. It in some ways goes back to 2019 when the various individual operators or stevedoring companies decided to move forward with a proposed joint venture. At that point in time, they had discussed and presented to the commission a proposal for a joint venture that would cover both the ports of Charleston and Savannah. And that joint venture was going to join all the operations at the various terminals in those two ports under one sort of at that time, when the respondents, the individual respondents, not the joint venture respondents, presented that to the commission, they took the very strong position that they were subject to this commission's jurisdiction due to the unique nature of their role in the two ports in Charleston and Savannah. They argued very strongly in their documents and their submissions to the commission that they had a control over terminal facilities that put them within the ambit of the commission's jurisdiction, that they were therefore marine terminal operators in addition to the actual Port Authority marine terminal operators in those two ports. As we know, a marine terminal operator under the Act is anyone who's in the business of providing wharfage, dockage, warehouse, or other terminal facilities. And pursuant to that process, the General Counsel issued its opinion, despite what the respondents had argued, that the Commission's jurisdiction did not encompass their role at that ports, nor did their proposed joint venture fall within the jurisdiction. So the ILA then years later files a private complaint with the commission, and the immediate reaction, understandably, by the respondents is, hey, you know, we're not under the jurisdiction. We did our best to argue that, and we lost that argument, and you're going to lose too. But there's a few other things that took place and that I think are important to realize. The commission should evaluate its jurisdiction based upon a full evidentiary record. The commission evaluates each terminal on a case-by-case basis, looks at the facts on the ground, and determines how those facts are playing out and whether or not jurisdiction exists over a particular entity. When the respondents in this matter moved the ALJ to bifurcate the case, the attorneys had a discussion, and in the motion, the understanding was if we bifurcate the case into jurisdiction and then on the merits, we can save time and energy and resources. The respondents were confident that they could show that the commission did not have jurisdiction. The ILA opposed that motion, but understood at least that this was a way to address the situation. The respondents said, we want to move for summary judgment after some discovery. The discovery will allow the ILA to respond, and then we can proceed from there. So what happened, though, was not precisely what the ILA was expecting. The ALJ ordered a very, very abbreviated discovery, a very limited discovery. And first of all, no depositions were allowed, no third-party discovery. After the discovery order issued, there was a discovery dispute between the ILA and the respondents. The ILA had requested certain correspondence, emails, any documents that were between the joint ventures in the two ports and their direct customers, the carriers, because they bill the carriers directly. They negotiate with the carriers directly for both stevedoring and for the gate operations. And those direct contracts, those direct contractual relationships, we thought were supremely relevant to whether or not they had the requisite control and the requisite relationship with the carriers to form the basis of jurisdiction. Those documents were not forthcoming. The ILA was able to get some affidavits, and Mr. Thomas has accused the ILA's affidavits of being conclusory, and we can accuse his affidavits of being conclusory. But unfortunately, that's sometimes the nature of affidavits, especially early on. The affidavits that we proposed were when we were told by the judge that we weren't going to have a summary judgment motion because the burden was not going to be on the respondents to prove no genuine issue of material fact under the Rule 56 of the Federal Rules of Civil Procedure. Instead, the ILA was going to have the burden of proving jurisdiction, which is completely understandable. That's how the ALJ wanted to proceed. But under that sort of posture, with no depositions and no extensive paper discovery, especially the relevant discovery of emails or contractual relationships between the customers and the entities at issue, it's difficult to prove anything beyond a genuine issue of beyond the summary judgment standard of no genuine issue of material fact. Consequently, we did try to proceed under the Rule 12b2 standard of a motion to dismiss for lack of jurisdiction. And that standard, we clear, is the standard of prima facie showing. There's a lot of back and forth with the ALJ, and the ALJ sort of dismissed that. But both the respondents and the ALJ have cited a lot of cases to say that that they could make a finding of fact and could actually determine which evidence propounds over the other. The preponderance of evidence finding just based upon bare affidavits. So no depositions, no cross-examination of witnesses, and very limited discovery. And none of the cases, and I've been frank with Mr. Thomas, I don't practice much in front of the commission, but I looking at the commission cases, looking at other administrative cases, looking at the Federal Rules of Civil Procedure, I've never seen somebody make a decision on dueling affidavits, make findings of fact on disputed facts based upon affidavits. So I think that was the preliminary error here, that needs to be rectified. I don't think the commission should make a decision about its jurisdiction under what I believe is a large procedural error. The commission is not a federal court. It is an administrative agency. However, it is follows the rules of federal procedure, and it does not have to have the same sort of formality that a court does. That's true, but the rules of federal procedure could be allowed some sort of, telephone hearing or some sort of tape recorded depositions with cross-examination. I mean, cross-examination would really serve to elucidate the relationships between the joint ventures, Charleston Stevedoring and Gateway in the respective ports, and their specific unique contractual relationships with their customers, their unique customers, the carriers. Moving forward to I think what we are faced with then is there's no preponderance of the evidence standard here. The ideal situation would be to remand this for additional discovery. And then perhaps we could do Mr. Thomas's summary judgment motion if that's what he wants to do. But I don't think the commission decided that it has no jurisdiction over entities simply based on this abbreviated record and findings of fact based on disputed disputes. Moving on to the undisputed facts. I mean, the disputed facts some of them are more relevant than others, but there are some very genuine issues of disputed facts that are in the affidavits about how the terminal operates, particularly with the gates. But the undisputed facts are pretty clear and do show already that the gates, which are terminal facilities, are operated exclusively and solely by the respondent joint ventures, Gateway and Charleston Stevedoring. The Port Authority does not get involved with any of the contractual negotiations that Charleston Stevedoring and Gateway have with the carriers, both for Stevedoring, but particularly for the gates, a situation where in order to even gain access to the terminal, you have to be able to negotiate and agree upon terms and then pay that fee as agreed. And in that regard, the ALJ focused a great deal on the Plaquemines case, which is something that is a case that is definitely analogous to our case, but not completely by any means. The Plaquemines case, as everybody seems to be aware, dates back to the 1980s. Mr. Thomas has pointed out that it has caused some controversy. It was very much a reach for the commission's jurisdiction, and the commission was upheld by the DC Circuit. But that was a situation where a government agency passed a statute and required certain tariffs be paid, and pursuant to at least the statutory language, that somebody or a carrier or another entity could be barred from the Plaquemines Parish terminals if the tariff was not paid. The difference between Plaquemines and this case are very instructive and maybe more important than the similarities. Plaquemines Parish is similar to this case in that both in this case and in Plaquemines, on the current record, the ability to bar somebody from the terminal is somewhat theoretical. The ALJ made the point that we had not been able to show a single time where somebody was turned away at the gate by the joint ventures. But the specific facts on the ground is much more Plaquemines is much more of a reach. This is much more of an easier case of jurisdiction because it's clear, even from the undisputed limited record, that the joint ventures control the gates, as that term is normally used. They have a lease of the entire gates. It's staffed only by the joint venture's employees and supervisors, and they negotiate separate agreements with the carriers on those gates.
I'm sorry to interrupt,
Go-
Sheridan.
Yeah,
Do you have examples of the separate agreements?
the separate agreements?
Yeah.
Well, I mean, the LGA found as fact that they have exclusive ability to negotiate the terms of their agreements, both for stevedoring and for the gates.
And yeah, I know that you don't have a specific instance where they've sort of turned someone away, but can you at least give us the categories of where they would turn somebody away?
So, okay, well, Mr. Chairman, I mean, there's two answers to that. There are situations where we have affidavits that the employees have been forced to turn people away because of various administrative clerical matters where their papers were not in order, where there was not some sort of administrative or clerical thing that was correct, and they had to come back the next day. So
And was that, do you have affidavits to the effect that, or some other evidence that those policies were set by the the private entity, or were those policies set by the Port Authority and they were just carrying it out? Can you make that distinction?
So, Mr. Chairman, and that's my sort of second answer to the question is we show that there was a practical ability to, they operate the gates, that you have to go through them before you get into the terminal, just from a very practical standpoint. But it would have been helpful to have evidence of the actual contractual relationship between the joint ventures and the carriers, what causes them to pay the fee, what does the fee entail, what does the fee provide the carrier, what does the carrier promise the joint venture, and that's the sort of documents or evidence that we do not have other than sort of conclusory affidavits. For example, they said we have no authority to turn away a truck based upon commercial reasons. Sort of a vague conclusory statement. I submit to you that we do know that they are the exclusive provider of gate services, that they charge a fee, and a fee in any business sense means it's a payment for something in exchange. And that fee alone, besides without having any sort of confrontation or turning away at the gate, is enough to cause a gateway, a hurdle to jump over.
But to the best of your knowledge, do they have complete control over that fee, or does the employing Port Authority have to agree to it?
They have complete control, but it has to be commercially reasonable. But I mean, we're talking about a situation where it is a unique negotiation. And if, for example, the Port Authority agrees that the fee is commercially reasonable, if it is objectively commercially reasonable, but they're still not getting paid, what is the ability that they have to continue to do business with them? Are they forced to continue to do business without being paid? Is the Port Authority requiring them to?
Does the fee go to the Port Authority in that case, or does the fee go to the company?
No, it goes to the company. We're talking about the fees that the company charges and invoices. But we don't know, there's nothing in the agreement between the Port Authority and the companies that says you have to work for free, that this fee is just a suggested donation. A fee means something in the business sense. Now, obviously, customers want to pay the fee. They want to get their cargo moving. But if we're looking at some jurisdiction, we have to, think about the hypothetical situation. Who is in charge of this fee? It's the company. They've negotiated. What will they do if they don't get paid? Conversely, what will they do if they can't come to terms on a fee? If they can't come, the carrier or the shipper will have to go through to another location. That's what a fee means. And that's what the commission is here to regulate, is the amount of money that is charged to the shipper, the shipping community. So this is one fee that is imposed not by the Port Authority. The Port Authority has some input onto whether it's commercially reasonable, but at the end of the day, it's a contract, a unique contract that is not involving the Port Authority. The privity of contract is between the carrier and the joint ventures.
How is the carrier, the trucker, informed of the fees?
How is he informed of the fees? I think that's charged to the carrier, so I'm not sure if the trucker is necessarily aware personally.
But how, is there a tariff?
No, it's not a tariff.
Right.
It's a fee. But it's
But the fee is not filed in a tariff.
well, because I mean, that's sort of a little bit circular, right?
I see.
Perhaps it
I
would
think that
be,
we're talking past each other.
but it would be
I understand that
because the commission doesn't have jurisdiction, so it wasn't filed, you know? Okay, yeah,
Mr. Sheridan,
yeah.
a more basic question. Do the gate checkers control access to the terminals?
Yes, I think that could be developed, or I think they do. Did they represent, you know, the respondents represented to the commission that they control access to terminals in 2019. That's the language they use.
If you don't have why have checkers at all if they don't control access? And are they the only ones who would turn a truck away, for example, would be the checker?
No, but they wouldn't be the only ones. They pointed out there was security that was not run by the joint ventures who would also, who were the first gate to the terminal.
I see, but security doesn't normally deal with cargo.
No, it's not really something that's in the commissioner's jurisdiction at all. It's not something, yeah.
Right,
yeah.
right. But the checker is something, you know, it touches upon our world, so it's.
Checking is a terminal, service. Yeah, so I think that the record could be more fully developed on that issue. I think the undisputed facts show that the joint ventures are involved in a fee service, that they are requiring payment as a result of them letting people into the terminal. And I don't think you need to have an actual confrontation or some sort of turning away. They do control the terminal. They do turn people away in other issues. And perhaps we could, if we did more discovery, find that. But I think we would definitely find situations where there was letters and other demands for payment. Thank you.
Before you go, Mr. Sheridan,
Sure.
and you've been very good about the time, but I do want to ask
Sure.
your answer to that question. It's the exact thing you were asking, but I just want to develop it a little bit more. If allowed discovery, what kinds of things would you look for? What kind of documents if you had been allowed discovery, would you be looking for in order to address the jurisdictional question?
Well, precisely what we've just been talking about, what the relationship between the carrier and the joint venture is in terms of this fee arrangement, this contract that says you pay this fee, it'll be billed in what way, it'll be due when. In return, this contract allows you for how long. How is a contract terminable? If the contract is terminable at will, then that gives a certain, if you can't contract with the gatekeeper, you're not going to get to the terminal.
And you asked for that information, but it wasn't provided and it's not.
But yeah, we had a very brief, and we asked for, we tried to talk about it and the ALJ did not provide it. Yes.
Okay. Stand by 1 second.
Yes, I'm looking at, it's a finding of fact on page 12, finding of fact, page number 45. Gateway does not and has no authority to refuse entry to trucks or cargo on economic or commercial grounds.
Yes. That was finding a fact that the ALJ made upon disputed facts of the two affidavits.
I understand.
Yeah.
Thank you.
That's actually, that is helpful. Just want to make sure. Okay, thank you, and I apologize for making you go late. That was.
Yeah, are you done with them?
Yeah, that's why I asked you.
Well, I was, yes. I did.
Okay,
Just when a checker turns a truck away, if they don't accept them, there'd be a record of that. And so it was possible that there could have been evidence that would show that there was control exercise by the checker's employer, my guess is.
Oh, yeah. And that's, I mean, if there was a record, then we would want that. So that, what we're talking about, the relationship, what kind of turn-away that they had, a physical.
Exactly.
But I was saying, even without the turn-away, there could have been other things like, you know, get your bill paid or else, you know, do not be coming by with your cargo.
it strikes me as curious that evidence about the transactions weren't allowed, though. But it would seem that would be plenty of evidence out there potentially.
Oh, I'm sure there is. I'm sure there is. I mean, it was a very abbreviated schedule. Thank you. Appreciate it.
Thank you very much, Mr. Sheridan. Now, arguing on behalf of the respondents, Mr. Matthew Thomas. Mr. Thomas, you have 30 minutes. Thank you again, and please proceed.
Thanks very much, Mr. Chairman.
Actually, because we just went over, we may, you feel free to go over a bit here too, and we'll probably have questions, but so you'll end up with roughly 33.
Great. Thanks very much, Mr. Chairman. And hello and good afternoon, commissioners. Matthew Thomas of Blank Rome LLP appear on behalf of the 5 respondents in this proceeding. The presiding officer's decision to dismiss the complaint for lack of jurisdiction over any of the 5 respondents was correct on the law and supported by substantial evidence. Respondents ask that the decision be affirmed. I'm just going to jump in and continue on some of these gate questions that they were just talking about. One of our core sort of big picture points in this argument is that we have 5 individual respondents here, and a lot of the discussion and complainants briefing focuses on the respondents en masse or in toto. The commission has jurisdiction over the respondents. We want to respectfully remind the commission that we're talking about 5 separate companies, and there's not any basis presented here to engage in a veil-piercing exercise such that a finding of jurisdiction over one company at one time, or finding a jurisdiction that one of the respondents provided marine terminal facilities at one particular instance, leads to a finding of jurisdiction and MTO status for all of the companies. With regard to the gate issues, in particular, the concerns about discovery, the ALJ relied heavily not just on the declarations of the parties and competing declarations of the parties, which were very fulsome. The ALJ relied in particular on the declarations of the South Carolina Port Authority and the Georgia Port Authority. These are, although they were the drivers for the consolidation of the stevedoring operations in those 2 ports, the port authorities are not parties to this case. They did, however, put in helpful and detailed testimony explaining intensively what the nature of the relationship is with previously with the legacy stevedoring companies and now with the current stevedoring companies, Gateway and CSC. The declarations were also backed up with significant production of contracts, the license agreements and other agreements between the ports and the various respondents. Old contracts with the previous legacy stevedores, and then the new license agreements with Gateway and CSC. So that's the body of evidence here that really defines the nature of what these parties are doing. We've submit that additional discovery, production of reams of emails and searching and things of the correspondence between the stevedoring companies and the carriers, that's not necessary, and that's not relevant to the determination of what's happening on the ground. The declarants, both on the ILA side and on the respondent side, have firsthand knowledge of what's happening on the ground in those ports. And the ports certainly know what's happening on the ground in their ports. Those are the appropriate sort of witnesses here, and that's what really the ALJ relied on. Just on that issue of whether the respondents or really whether Gateway and CSC can turn parties away for non-payment. I know that in Charleston, gate operations are handled by Charleston Gate. That is a different company with a different shareholding structure than CSC, the respondent in this case. Charleston Gate is not a party to this case. The three, the shareholders there are MTC East, also not a Ports America affiliate, not a party here. SSA, and Series Terminals, who are parties here. But there also is another shareholder in Charleston Gate. So it is not an alter ego of somebody you have before you. So it's important to recognize those. Then the declaration, the declarations of the parties relating to to Gateway and the operations in Savannah really lay out in detail that the carriers are billed by Gateway on a monthly basis. They have no authority to turn away cargo at the gate or refuse cargo at the gate. But these processes really are detailed in the existing record, which we think is sufficient.
Excuse me, Mr. Thomas, you said they have no authority, so then cargo does not get turned away at the gate?
Correct. The carriers are billed on a monthly basis. They are not, the cargo is not turned away at the gate companies can't turn away the cargo at the gate for non-payment, and no payment is made at the gate. So so just turning back to some of the sort of broader key points here. So as the record reflects, the dispute arose as a result of policy determinations reached independently by the state port authorities in Georgia and South Carolina, who were not parties to this proceeding, to transition to a single stevedoring provider model for their container terminals in Savannah and Charleston. The change was made to improve operational efficiency and throughput in the face of rising cargo volumes, as the testimony of those ports indicates. As a result of the port's decision, the then existing stevedoring providers, that is Respondents, SSA Atlantic, and Series Marine Terminals, along with a non-party to this case, Marine Terminals Corporation East, they ceased operating their competing legacy stevedoring operations in 2020 and 2021. The Georgia and South Carolina port authorities, however, enabled joint venture companies that were owned by the three legacy stevedores and allowed them to begin providing stevedoring in each port. Those joint ventures are the Respondents Charleston Stevedoring Company, or CSC, which began operating in May 2020 in South Carolina, and Gateway Terminals in Savannah, which added stevedoring to its existing gate operations services in Savannah in October 21.
I'm going to ask this, and I know it's a loaded question.
Yeah.
But what do you mean by stevedoring? Can you tell us what stevedoring is by what you're saying when they provide stevedoring services? What does that mean?
They are loading and unloading cargo from the vessel to a point of rest and moving cargo within the terminal facilities. There is fortunately a really robust explanation in the factual record of what exactly they are doing over there. And there's contracts with the port or in the license that the two stevedoring companies have with the two ports. It really delineates exactly what functions they're providing. So,
Mr. Thomas, so what's a marine terminal operator do then? Stevedore, how are they different?
a marine terminal operator under the Shipping Act is in the business of furnishing marine terminal facilities to a common carrier or a domestic carrier and a common carrier. So this is really the key statutory issue here. Who is providing the facilities? And that's just straight out of the text of the Shipping Act. Fortunately, very simple statute, very simple text. Who provides the facilities?
And in that facility, it's okay.
I had a follow-up, Mr. Chairman. Mr. Thomas, the Lobiando Act extended prohibitions under the Shipping Act to certain covered services, including tug services, amongst others. Do you believe that the Lobiando Act alters the commission's jurisdictional analysis?
Good question, Commissioner. And no, it doesn't. It does not change the statutory definition of who is a marine terminal operator. That has stayed consistent through the 1984, since the passage of the 1984 Act.
So just two or more ocean carriers collaborate. In services, there would almost, you could see where the FMC could exert jurisdiction over stevedoring.
Well, for the FMC to exert regulatory authority or power, you need a couple of things. First of all, you need personal jurisdiction over who you're trying to regulate. Is this an ocean common carrier? Is this an NVOCC? Is this a marine terminal operator? You have to check that box by looking at the definition right there in the Shipping Act. Do we have somebody we regulate? The second question is, are they doing something that we regulate? So some of the cases that complaint cited, like Port Canaveral and Petchem, those cases were about are these the kind of services that the FMC regulates? Is this receiving, handling, or storing or delivering cargo? Thanks. So sort of a two-step thing. Do you have a regulated party? And here the answer is no. And if you have a regulated party, are they doing a regulated thing like tug services and things like that? So we're at that. So step one.
Mr. Thomas, the South Carolina Port Authority and the Georgia Port Authority are operating ports,
Correct.
as opposed to our landlord ports that enter into lease agreements
Yes. That's right.
with their terminal operators. Right.
Yes.
Now, obviously, this is different, at least the lessees are different in control than the lessees, as in landlord ports.
Yes.
Right. Is there anything that prohibits the ports from organizing their businesses as arms of the state by using leases rather than to be lessees rather than lessors?
Yes. I mean, that's one of the interesting things about ports and terminals in the United States, is that different regions and states organize their ports differently. You know, in the Southeast, there was this tradition of having operating ports where the state port authorities actually operate the marine terminal. They provide that facility, you know, the land and the crane and warehousing. And then they may have private companies in as concessionaires or contractors operating in there, but those concessionaires, like my clients, aren't providing any facilities. In other places.
Well, that's right, that they are, they have a license.
Yes.
Which is a lesser possessory matter than a lease.
That's exactly right. So moving up the coast, you've got in Port of Baltimore up here, New York and New Jersey, you've got the landlord port model where a terminal is actually leased, physical piece of land, marine terminal berth, leased to a private company. And then that private marine terminal operator is actually providing that facility to carriers.
So are you saying that implicit in the word facility is it has to be something physical? It cannot be services?
That's absolutely correct. Yes. If you're providing.
So Congress did a really poor job of selecting this term marine terminal operator, because if somebody operates something, it's not the term operator, you're doing something, it's a verb. I mean, operator is a noun that depends on the verb of operating something, but operating something doesn't have anything to do with a physical facility. You could have a physical facility and not operate anything, or you could operate stuff on it. So they just did a very poor job of picking that term.
Oh,
Well, I think, Mr. Tom, depend on the terms of the license.
it absolutely turns on whether the commission's jurisdiction and MTO status determines whether the company operating in there has rights, property rights to the facility itself. If it's operating.
And operational rights
Yes.
as well.
Yes, rights to operate and control that facility. I don't know that at least the is this my mic that's feeding back in sort of a weird way? Sorry. Oh. So the definition is pretty simple, that it turns on whether respondents are providing wharfage, dock, warehouse, or other terminal facilities. So I think if we went down there and had a stroll around, we should have done this really in Charleston or Savannah. But if we were down there and we had a walk around, we could look at the facilities, look at wharf, dock, warehouse, physical facilities, and say, who's providing that, who owns it or who leases it, and who controls that piece of land. And then you'd be able to sort of see and touch the fact that our clients are not providing any of those facilities.
Could we get back to focusing on control?
Yes.
Could you discuss the 2019 General Counsel's opinion on
Yes.
control and how it applies in South Carolina and Georgia?
Yes, absolutely. So arising out of those Plaquemines cases, the two Plaquemines cases in the 1980s, is what's called the control theory for marine terminal operator status, the control theory of FMC jurisdiction, which is problematic because in some ways it's very much of its time, sort of a relic of 1980s administrative law, where agencies were blissfully free to kind of ignore the language of the statute and go and opine about what Congress's broader intent was, and then were afforded deference by the courts to come up with sort of definitions and regulations that did that. So the control theory. The Commission and the DC Circuit looked beyond the text of the Shipping Act definition for marine terminal operator and focused instead on Congress's perceived purpose. In those cases, the Commission and the DC Circuit agreed that port, harbor, and terminal service districts' combination of offering essential services and controlling access to marine terminals for a fee rendered it the public port a marine terminal operator. And this control theory really is the basis of complainant's argument that our client is an MTO. And honestly, it was the basis of my complaint, of my argument, when we first approached the Commission and said, hey, we think these parties back in 2019 may be MTOs here. And that approach was really narrowed. It was rejected by the First Circuit in the PRPA versus FMC case, and significantly narrowed. In that case, the Commission described the test as follows. What's necessary for jurisdiction to lie is not a predetermined level of activity, but rather enough control to have an effect of a nature the shipping statutes were enacted to regulate. So it's a very sort of vague, open-ended case. DOJ in those cases broke with the FMC and before the courts of appeals opposed this, said this is not consistent with the statute and piled on and said the commission made this up out of whole cloth. The First Circuit decided not to adopt that control theory.
Do you believe that we should revisit the 2019 General Counsel opinion?
I think the 2019 General Counsel opinion was correct. I think he correctly said that these parties, even looking at the issue of control, these parties did not have enough control over marine terminal facilities to warrant them being considered a marine terminal operator. You know, and we took that back and looked at that and studied, and we recognized that was the stronger argument here. And we recognize really from a practical standpoint that it's not the 1980s anymore. Finding these clients who are not public port authorities at all, finding these clients to be marine terminal operators would really be a big expansion of this vintage 80s control theory. And it would really blow right past the text of the Shipping Act. And really what we saw is no chance that the Fourth Circuit or the 11th Circuit would go for such a sort of extra statutory broadening of the commission's authority. And DOJ would likely be all over this because it would broaden antitrust immunity and the commission's regulatory authority over parties that don't have a marine terminal, that don't provide terminal facilities, don't provide services. So broadening antitrust immunity, broadening regulation, that's not in style these days. So we recognize that the General Counsel's opinion in 2019 was correct, and the parties went off and put together their joint venture under the antitrust laws. So a couple of other just core really foundational issues.
Mr. Thomas,
Yeah.
I'm still troubled by the fact that the Lobiando Act existed, and it seemed like they definitely thought stevedoring ought to be under the FMC jurisdiction. Because you mentioned vague areas and you talked about missed here, missed there, and so I'm following and I'm learning as you testified. But so I'm curious, how does that not, is it a relic for the past?
Oh,
It's
well,
not that old, isn't it?
No, correct, yes. But the Lobiando Act did not fundamentally change the definition of marine terminal operator to render stevedores marine terminal operators. That was not that wasn't the effect of those. I mean, it did impact agreements with regard to essential services, but that's just jurisdictionally a different issue than what we're talking about here, which is who's a regulated MTO.
So, Mr. Thomas, do you agree that parties should be able to rely on former general counsel's opinions as precedent?
I do. I mean, with all due respect to the commission, I mean, a legal opinion from the general counsel is one thing, and a final agency order obviously has much more weight and precedential value in that thing. In that case, the general counsel explained to us that they had looked at options and they had polled all the commissioners, and that legal opinion represented the consensus of the agency, of the commissioners, and although it wasn't a final agency order, but it was implemented as policy through the agency. We were allowed to withdraw the agreement and proceed with the JVs without enforcement looking at us or agreements chasing us. So in that situation, we thought certainly this is the policy of the agency. And I think a reviewing court would say, hey, in 2019, that this was the policy of the agency.
Thank you.
So a couple other very sort of foundational points here that we'd just like to kind of remind the commission about. So we talked a little bit about how jurisdiction has to be made on a company by company basis. You can't impute from one respondent to the other this this MTO status based on their activities.
Actually, I'm glad you got back to this because so are you saying that if any of the company, even if one of the companies was that we did have jurisdiction over one of the company's actions, the case should have been dismissed because we don't have jurisdiction over all the companies?
If you find jurisdiction over one of the respondents, then the case is not dismissed in total. It's dismissed with regard to who you don't have jurisdiction over, and it proceeds with whoever you do find. And so it would the case would then go back to the ALJ presumably on that. And so other sort of key point here, MTO jurisdiction is facility specific. And that's that line of cases, the Alaska cases, that auction block company versus City of Homer, in which they commission and the Court of Appeals agreed that just because a company is a marine terminal operator for the purposes of the Deepwater dock or the Pioneer dock, it's not an MTO across the street at the fish dock. So we're really looking at facility by facility, parcel by wharf parcel. Are you a marine terminal or are you not?
So I mean, you're very familiar with non-operating ports, landlord ports.
Yes.
In a landlord port, why is what we currently view as a marine terminal operator a marine terminal operator? They may lease the facilities, but they don't provide the physical stuff is owned by the landlord port. So why should even they be considered MTOs?
Because they lease that.
So it has to do with whether it's a lease or if it's a contract for services, they should not be. But if it's a lease for land, they should be. Is that where does that?
Yes. Yeah. And this is a great bright line test here. If you have a marine terminal, if you own it, if you lease it, it's your facility, and you're providing it for common carriers to use it, run cargo through, you're a marine terminal operator. If you are in somebody else's marine terminal and you're providing stevedoring or M&R or IT services, anything in somebody else's terminal, you don't own it, you don't lease it, it's not yours, you're not a marine terminal operator. And this is mercifully a pretty straightforward.
I guess, but I don't understand why all the landlord ports don't just change their leases to contracts, and then the current MTOs there won't have to worry about being under the jurisdiction of the FMC any longer. And of course, as long as those landlord ports are ultimately owned by a state or government entity, then they won't have to worry about it either. Doesn't that create a huge loophole? I mean, maybe we'll see a massive restructuring in the next year.
Can we just tack on like an extra 90 minutes to just chat about infrastructure finance?
I think we're really talking about the difference between a lease inherently
Yes.
and a license that is limited and depends on the terms that a grantor gives to a licensee. And those two possessories are very different. And landlord ports obviously use broad leases.
Yes, it's really the nature of the agreement. Does the agreement, like a lease, and I mean, just think of it like an apartment or an apartment or office or, you know, WeWork or something like this, does this give you a right to a defined piece of land or berth or crane or something? Do you have a right to use it, operate it, for however long? Or do you just have a right to go in on somebody else's facility and move cargo in there? And
So in what I'm talking about, they could technically restructure it as a contract, but you would say for legal purposes, it would still be, they would still be the MTO operator because, you know, they can do that legal restructuring, but it would just be.
Yeah, I mean, marine terminal leases are very interesting because municipalities, oftentimes these are very long-term instruments, and they want that certain revenue stream for 30 years or 50 years. They're looking for capital investment from their tenants that are coming in. They are shifting liability for stuff that goes wrong in that terminal to these tenants, and so there's a lot of reasons why landlord ports do it that way. I'm running pretty short on time, but I just wanted to flag up a couple of just sort of a separate issue here. In our November response to the complainants' objections, we did a couple of things. I mean, first, we agreed with the ALJ's ruling on jurisdiction, but also we asked that the commission review de novo the ALJ's November 7th ruling on our motion to dismiss for failure to state a claim. And that ruling, that November 22 ruling, was particularly concerning because the presiding officer didn't apply or even acknowledge or engage at all with the decades of precedent that controls what's a properly pled unreasonable refusal to deal claim and discrimination claim under 41-106-3 and 2 respectively. And the most sort of worrying part of that ruling was that the ALJ found that under 41-106-3, a cause of action may lie for an unreasonable refusal of a waterfront employer to negotiate with a longshore union, and she ordered the parties to proceed to discovery on that claim. This idea of unreasonable refusal to negotiate with a union, it's clearly outside the scope of the Shipping Act. It's contrary to the Maritime Labor Agreements Act of 1980, which is currently codified in the Shipping Act at 40301D. That 1980 Act placed collective bargaining firmly outside the commission's jurisdiction, ordering discovery into the respondents and carriers' conduct of labor negotiations with the union for the purposes of FMC regulation of that bargaining. That's clearly outside the scope of the commission's authority.
Yes, Mr. Thomas, do you agree that with the ILA in this matter that the commission has jurisdiction? If we agree with the ILA's position, would the commission in effect be involving itself in labor negotiations?
Under that particular count in the complaint, that one count in the complaint goes squarely to the sufficiency of the employer's labor negotiations with the unions. So yes, it would be that count puts the commission very squarely right in as a labor regulator. And so in our motion to dismiss, we discussed the 1980 Act and the legislative history and Garmin preemption for matters under NLRB. And just none of that was acknowledged at all by the presiding officer, which we think was just on its face arbitrary and capricious. So there were two other counts that we flagged up in that motion to dismiss, where similarly the presiding officer just didn't acknowledge any of the authority. The Series case and the Marr case regarding the standards for a properly pled refusal to deal claim and a properly pled, the 4-part test for a properly pled discrimination claim here. Very, very briefly, the complainants assert that the respondents, again, that's the mass of respondents, have refused to deal with, have engaged or refused to deal because the legacy respondents stopped operating. And there's not a specific identification of who was refused, who was subject to the refusal to deal. It was just more along the lines of they stopped operating, and so they have refused to deal sort of writ large. And again, on the discrimination claim or the prejudice claim, there's no allegation that any particular party was discriminated against, as the series precedent and other precedents require. There is just a pleading of a series of facts that look like a 6G case.
But this is really beyond the jurisdiction issue,
Yes,
right?
yes. So those are issues that, should the commission find jurisdiction over any of the parties and send it back to the ALJ to proceed with discovery on any of these cases, we would ask that the commission take up those issues de novo. So.
One other question before I let you go anyway. And you may not know the answer to this, but to the best of your knowledge, do any of your clients issue demurrage bills to shippers? If something is do they provide that service?
I don't.
Appreciate you entertaining the questions.
Absolutely.
Let me just. Thank you very much, Mr. Thomas. And thank you for respecting our time limits, even if we don't completely respect our own time limits. You certainly did. So I really appreciate it. Thank you again.
We can keep going if you.
Actually, since you said it, yeah, 90 minutes on and transportation. Yeah, I'm the wrong person to ask on that. I probably would have said yes, but okay. Yeah, we'll have more questions if we do the 90 minutes. But anyway, no, we appreciate the offer. And on behalf of my colleagues, if not myself, I will decline at the moment.
Thank you all very much.
Thank you. So, Mr. Sheridan, you have between, I guess, 10 and 13 minutes, something along. Okay, 13 minutes, and hopefully I'll just talk more. I'll be more disciplined anyway. Thank you again.
Thank you again, commissioners. So just quickly in response, I did want to point out that the Charleston Gate entity, which Mr. Thomas referenced, is a 2/3 owned, I believe, what I understand, by Charleston Stevedoring. I do know that Charleston Stevedoring has the license from the Port Authority in Charleston in South Carolina to conduct exclusive license to conduct the gate operations. And the Charleston Stevedoring everyone is employed by Charleston Stevedoring. Talk a little bit about, I guess, some discussion about what's a terminal service and what's the actual terminal operations, or what. I do think the commissioner should be aware that there are various ways to arrange a terminal such that the entity is operating the terminal, as that term is commonly used, and operating the terminal as a marine terminal operator under the law. In that regard, Commissioner Dye is correct that a licensing agreement is a lower version of a lower possessory interest in the property. I'm not sure if necessarily, state real property law is what the commission wants to hang its hat on as a bright line, as Mr. Thomas spoke about. I mean, leases can have a lot of preconditions in them. Some of them are stronger, some of them are looser, some of them can be canceled on short notice, and licensing agreements can be very broad. And the licensing agreement, if you want to review, it gives exclusive jurisdiction and use of the gates to the joint ventures in this case. There's no employees or oversight by the port authorities in the gate structures. So I think you need to look something more fact specific and not just the real estate law. Uh, Again, there was a discussion about the carriers billed on a monthly basis and a discussion about the Plaquemines case. The Plaquemines case has been somewhat discredited by the First Circuit. But it was, it was adhered to or cited frequently by the ALJ. She really relied on it. And the Plaquemines case, as I said before, if it was an overreach or close to an overreach, this case is much more, less of that. In Plaquemines, the Port Authority was a government authority, but had no possessory interest at all in the terminals. The terminals were privately owned and privately operated. They did impose a law that required that tariffs be paid by terminal users, and that law included both civil and criminal penalties, and also the threat that somebody who did not pay the tariff would be barred from the terminals. It's not at all clear, even if you read the commission's decision, how this government agency would bar private parties from private terminals. Possibly you would need a court order. It's a theoretical possibility. And again, there's no connection to operating the terminals that the Port Authority in that case had. In this case, the companies, the joint ventures, are involved in the operation of the terminal from stevedoring, almost in the stevedoring's exclusive. The yard planning is more or less exclusive. The yard use is a cooperating agreement, and then the gates are an exclusive right to operate. So from the standpoint of operations, there is real operations going there, and there's also less than a theoretical ability to control access based upon the charging of a fee. And access control, again, I would submit to you, would be something less than an actual confrontation at the gate, but simply the expectation, the business expectation that if you pay a fee, it's for something, you get a service, and you won't continue to receive that service if you don't pay the fee. Go ahead.
So lease or not, if the respondents have any control over who goes in and out, that would then therefore make them, we'd have jurisdiction over that, or?
Yes, and I believe that, continues the Plaquemines sort of basic rule, but it's not quite as extreme as Plaquemines.
Well, do you agree with Mr. Thomas that under the definition of a marine terminal operator, a person engaged in the United States in the business of providing wharfage, dock, warehouse, or other terminal facilities, that only includes that facilities there, or that entire statement does not include any services?
No, I do not agree. No, that's it's a mixture of both. If you are a third party service provider, I understand the commission is not going to get involved with sort of people who are providing services, but the marine terminal operator is the entity that is dealing with the carriers and dealing with the fees. If they are, hiring other third party service providers and even a stevedoring provider to come in, but that's not the case here.
Do you think something like the term wharfage, it implicitly includes the service of what I guess how Mr. Thomas defines stevedoring, loading and unloading cargo from a vessel, moving cargo?
Yes, I mean, I think the terminal, the marine terminals defined with a parenthetical, I don't have it in front of me, and in related terminal services. So it is implicitly and defined in the regulations.
Yeah, I think, Plaquemine, I did find that it involved degree of its involvement in furnishing of terminal services to common carriers. So that's
Yes.
part Plaquemine. Okay.
Yes. And I suppose that the commission has made the decision that a stevedore who the carrier has no contractual relationship with has no license to operate exclusively, is simply hired to come on and do services hidden behind the scenes of the terminal operator. Perhaps that's not a terminal operator, but this is somebody who has a specific contractual relationship directly with the the carriers. And that's not, the Port Authority has no role in that contractual relationship. I do, let me see. In that regard, I would like you to take a look at the rate sheets that were produced by the joint ventures there at our appendix at 250 to 253 and 562 to 563. And there was also some flow charts that these are both things that
You don't need us to literally take a look at them at this moment.
Oh, no, no. I just want to read it into the record. I'm sorry. Yeah, the flow charts were something that was produced by the individual respondents when they first were submitting their petition or their request that they be considered under the jurisdiction. And the flow chart shows how integrated the operation is. And at certain points of times, the proposed stevedore would take the lead in actually directing the Port Authority how to handle the cargo. Other points in times, the Port Authority takes the lead. But it shows the
Mr. Sheridan, are these authorities in the license that you're quoting?
the license I'm quoting.
No, that you are describing.
The authority is that, okay, it's the flow chart is not in the license. It was something that was for a proposal. It is, and it's at the respondents appendix 540 to 541. So it's not specifically described in the license. It is consistent with the affidavits that we produced that showed that at certain points in times in the operation of the terminal, the stevedore or the stevedoring company or the marine terminal, but the private entity directs the employees even of the Port Authority as to how to handle the cargo. And so it's an integrated operation. It's a cooperative operation. They're cooperating the terminal.
And this authority is where?
Which authority, the flow charts I'm talking about or the affidavits?
No, that you just described about the authorities.
The authorities I described was the affidavits from my fiance, individuals who actually, I represent the ILA. These are just workers, but they are firsthand knowledge of how things operate. Okay.
All right.
Yes.
So you're not arguing that the state port authorities are not MTOs?
No,
just that
by no
they,
means.
that
By no means.
do they? I mean, could you characterize it? Would they share MTO? I mean, how would you characterize?
I'm not sure if anything needs to be shared. I do think that we should examine whether, in addition to having jurisdiction over the state port authorities, because of the facts on the ground, because of the ability to control areas of the terminal and specifically to control access to the terminal based upon actually charging fees and actually physical control over the gates, that this is something that has a discernible effect on the relationship between the shipper and the carrier. That's in the Act 2, and this is something that was in the jurisdiction of this commission, unlike would be more of a stretch, state government agency that is imposing essentially a tax on the cargo, which that's the Plaquemines case. If a state government agency charging a fee when it does not control or own or operate any terminal, if that makes it a marine terminal operator, then a private entity that is assisting in the operation of the terminal and charging fees directly to the carriers is over into the jurisdiction of the commission.
Question.
Sure.
Mr. Sheridan, thank you for coming here today.
Thank you.
As you're talking about the fees, the one thing that when I read this case that I was looking for in part of the discovery was the invoices. Who is invoicing who and for what? Did did you provide, or do you have any of those that you provided into the case or?
Well, that's one of the things that we asked for in discovery.
Okay.
And Mr. Sola, and I mean, the licensing agreement gives the joint ventures and both board the exclusive authority to contract and negotiate fees for both gate and stevedoring and to invoice the carriers directly without going through the port authority. So we know that they have that exclusive authority. We haven't seen those invoices. We haven't seen any attempts to collect on those invoices.
Okay, because one of my colleagues actually, I think, brought up detention and demurrage. Do you know if they're charging for that and other type of things? Which are 100% within the commission's jurisdiction.
Yeah, I understand. I believe there was an affidavit that they don't charge for demurrage. They were trying to argue that they did not charge for demurrage and therefore that they shouldn't be, a
Understood.
terminal operator. If you look at the flow chart, and I don't want to go too far over, but and it's consistent with the affidavits, the private entities take the lead with the stevedoring and removing into the yard. They cooperate with the Port Authority on the yard operations, and they take the lead with the gate and basically are exclusively providing the gate service. And they charge a fee for stevedoring on one end and a fee for the gate operations on the other end, and that's a direct fee that they negotiate with the carriers. So that's sufficient.
Sharon, I just have one more question.
Sure.
What is the ILA's interest in this matter?
The ILA's interest in this matter. At the time, we wanted to bring this action based upon the labor relations thing that was brought up, and we survived the motion to dismiss. The joint venture had particular bad consequences for some of the labor relations. Prior to the joint venture, the ILA had contracts with 3 different entities, and after that, the entities tried to impose a uniform sort of lowest common denominator on various terms and conditions of employment. I do submit that if that the jurisdiction is a preliminary issue. I mean, everybody agree that if there's the merits of the case cannot be addressed unless there is actually jurisdiction over the parties.
You're aware that the commission cannot become involved in labor negotiations.
Yeah, I agree, but the entities merging without the commission's input was something that the ILA was concerned about. What?
Right. Why was that?
Because the ILA had the mergers affected the terms and conditions of employment.
The negotiations.
Not negotiations particularly, but the terms and conditions of employment, the actual day-to-day operations of the employment. Yes.
Does it affects what the workers do?
Oh, yeah, it affects a whole myriad of items. Yeah, I mean, it affects a grievance procedure. It affects some
But does it affect like what services they actually perform, or is that not?
Honestly, I'm not prepared to speak on all the details.
No,
of that.
and
It may.
yeah. And I'm only interested to the extent that it would address a jurisdictional question. So let me,
So, Ms. Sheridan, planning, checking, stevedoring is all that's operations. And as I understand that model in Charleston, that, and there's some of that is intermixed with public employees, do some of that as well as ILA employees do other aspects. So they're interchanged, and the same cargo could be handled by a state employee and in the course of the supply chain, taken off perhaps by a crane operator, perhaps a state of South Carolina employee, and then put on a chassis driven by an ILA employee, planned in the yard to go to a location by an ILA clerk, and then get outgated by a clerk, possibly from Charleston Stevedore Company. So there seems like there's a lot of intertwining. And
Yeah, I think that's fair.
And that's all operations. That has nothing to do with labor relations. That's moving cargo just from here to there.
Yes, I mean, that's what we're discussing because again,
That's what I
the
thought. Okay.
jurisdictional issue is the preliminary issue here, and that's what the jurisdictional focus on. I mean, neither here nor there, but you know, the commission has an interest in ruling on its own jurisdiction regardless of the merits it may espouse. Yeah.
Well,
So I
Yeah.
just want to clarify one point. So there are no upcoming labor negotiations that would involve this decision.
No, I don't see how this is going to be involved in any upcoming labor negotiations.
So I just wanted to, Commissioner Dye, you cut me off before I wanted to get my point about the incentivizing cargo movement, which is, you're the mother of that phrase. And so I just wanted to give you due credit to you. Thank you. Incentivizing cargo movement is what the agency is supposed to be all about. So.
All right.
Yes.
I need to get my point across, which is to just thank Mr. Sheridan. Thank you again. Thank you and your team. I want to thank Mr. Thomas again and his team. I do want to do a special thanks in the record to the Surface Transportation Board because Chairman Primus and the board members have graciously made this their room available to us to do these things while our room is being renovated. And with that, again, I thank the staff at the FMC, and I again thank the two parties. This concludes the oral argument today. The commission stands adjourned.
Thanks, Mr. Chairman. Appreciate it.